This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. It's being reported that Colorado has ended qualified immunity for police officers. Let's take a look and figure out what's going on here, I guess by looking at the actual bill. So here is an act, Senate Bill 20-217, by these senators and representatives, but we really care about the text. The title of the thing is Concerning Measures to Enhance Law Enforcement Integrity and, in connection therewith, making an appropriation, which I'm assuming means a monetary appropriation. Law enforcement integrity. Then they go into a definitions section, so let's just skim through this and make sure we understand what the definitions are. Contacts means an interaction with an individual, whether or not the person is in a motor vehicle, initiated by a peace officer, whether consensual or non-consensual, for the purpose of enforcing the law or investigating possible violations of the law. Contacts does not include routine interactions with the public at the point of entry or exit from a controlled area. Okay. Demographic information means race, ethnicity, sex, and age, or approximate age. Peace officer means any person employed by a political subdivision of the state required to be certified by the post board. I'm guessing that means police. Physical force means the application of physical techniques or tactics, chemical agents, or weapons to another person. Serious bodily injury has the same meaning as it does in another section of the law. Tamper means to intentionally damage, disable, dislodge, or obstruct the sight or sound or otherwise impair functionality of a body-worn camera, or to intentionally damage, delete, or fail to upload some or all portions of the video and audio. Okay, so we don't want to disable, damage, dislodge, or obstruct the sight or sound of a camera, or intentionally damage, delete, or fail to upload some or all of the video. Incident recordings. By July 1st, 2023, all local law enforcement agencies in the state and the Colorado State Patrol shall provide body-worn cameras for each peace officer in the law enforcement agency who interacts with members of the public. So anyone who interacts with members of the public. Law enforcement agencies may seek funding. Okay. Except as provided in another section, a peace officer shall wear and activate a body-worn camera or dash camera if the peace officer's vehicle is equipped when responding to a call for service or during any interaction with the public initiated by the peace officer, whether consensual or non-consensual, for the purpose of enforcing the law or investigating possible violations of the law. A peace officer may turn off a body-worn camera to avoid recording personal information that is not case-related. When working on an unrelated assignment, when there is a long break that is not related to an incident, and in administrative, tactical, and management discussions, a peace officer does not need to wear or activate a body-worn camera if they're working undercover, so there's an exception there. These do not apply to jail peace officers or staff of a local law enforcement agency if the jail has video cameras, except it applies to jail peace officers when performing a task that requires an anticipated use of force. So jail peace officers have to have body cameras when they anticipate use of force, including cell extractions and restraint chairs. If the peace officer fails to activate a body-worn camera or dash camera as required, or tampers, as we saw above, with the footage or the camera, there is a permissive inference in any investigation or legal proceeding, excluding criminal proceedings, that the missing footage would have reflected misconduct by the police officer. Okay, so excluding criminal proceedings means they're not going to use the permissive inference. We would call this an adverse inference in the law if you choose not to answer questions. I take the Fifth Amendment or whatever. Well, if it's not a criminal proceeding against you, then yes, we can. The opposing counsel or the court or the prosecutor or whatever could use it against you in something less than a criminal proceeding. Heck, even in some criminal proceedings, the failure to answer a question could be used against you too. In this case, I think they're saying that in everything but a criminal proceeding, not activating your body camera or tampering with it can and will be used against you. in firing or in civil cases or something. If a peace officer fails to activate or reactivate his or her body-worn camera as required by this section, or tampers with footage, etc., any statements sought to be introduced in a prosecution through the peace officer related to the incident that were not recorded due to the failure creates a rebuttable presumption of inadmissibility. That means that the prosecution or the court can now assume that that evidence is not admissible, but the police officer or I guess the prosecutor, when they're on the police officer's side, could present evidence to rebut that presumption of it being inadmissible and overcome this presumption and get the information or the testimony or whatever into evidence. This does not apply to malfunctions as long as they're not aware of the malfunction or they were unable to fix it prior to the incident, and it has to be documented. In addition to any criminal liability and penalty under the law, if a court, administrative law judge, hearing officer, or final decision in an internal investigation finds that a peace officer intentionally failed to activate a body-worn camera or dash camera or tampered with same, except as permitted, the peace officer's employer shall impose discipline up to and including termination to the extent permitted by applicable constitution and statutory personnel laws and case law. In addition to any criminal liability and penalty under the law, if a court, administrative law judge, hearing officer, or final decision finds that a peace officer intentionally failed to activate a body-worn camera or tampered with same, except as permitted, with the intent to conceal unlawful, inappropriate actions or obstruct justice, the board shall suspend the peace officer's certification for a period of not less than 1 year, and the suspension may only be lifted within the period of suspension if the peace officer is exonerated. In addition to any criminal liability for failing to activate a body-worn camera or tampering with same with the intent to conceal, the board shall permanently revoke the peace officer's certification, and that may be only overturned if the peace officer is exonerated by the court. Oh, this is in an incident resulting in civilian death. And local law enforcement will establish the schedule for retaining recordings. For all incidents in which there is a complaint of peace officer misconduct by another peace officer, a civilian, or a nonprofit organization, through notice to the law enforcement agency involved in the alleged misconduct. So nonprofit, that means the ACLU as well. The local law enforcement agency shall release says the word, not just retain, they shall release all unedited video and audio recordings of the incident. That's all, including those from body-worn cameras, dash cameras, or otherwise collected through investigation. So that means security cameras too, even private ones, to the public within 21 days after the local law enforcement agency or the Colorado State Patrol received the complaint of misconduct. So that's on a complaint, you get the footage released to the public within 21 days. All video and audio recordings depicting a death must be provided upon request to the victim's spouse, parent, legal guardian, child, sibling, grandparent, grandchild, significant other, or other lawful representative, and such person shall be notified of his or her right to receive the recording at least 72 hours prior to any public disclosure. Notwithstanding any other provisions of this section, any video that raises substantial privacy concerns for criminal defendants, victims, witnesses, juveniles, or informants, including video depicting nudity, assaults, emergencies, medical information, mental health, victim interviews, minors, etc., any personal information of a person not arrested, financial information, government-issued identification numbers, etc., shall be redacted or blurred to protect the substantial privacy interest while still allowing public release. So there's going to be some great improvements in software helping people redact things out of video. Whoever's got stock in that, Maybe I should go buy some stock in companies that do that sort of redaction. Unredacted footage shall not be released without written authorization of the victim, or if the victim is deceased, the written authorization of next of kin. If redaction or blurring is insufficient, then the local law enforcement agency shall release the video to the victim, etc. In cases in which the recording is not released to the public, local law enforcement shall notify the person whose privacy interest is implicated within 20 days if they can, and inform the person of their right to waive the privacy interest so that the video can be released. A witness, victim, or criminal defendant may waive in writing the individual privacy interest that we just talked about. Okay. Any video that would substantially interfere with or jeopardize an active or ongoing investigation may be withheld from the public, except that the video shall be released no later than 45 days from the date of the allegation of misconduct. So if there's an ongoing investigation, they got 45 days, but no more than that. In all cases, when a release of a video is delayed, the prosecuting attorney shall prepare a written explanation. The written explanation shall be released with the release of the video. If criminal charges have been filed against any party to the incident, that party must file any constitutional objection to the release of the recording in the pending criminal case before the 21-day period expires. Only in cases in which there is a pending criminal investigation or prosecution of a party to the incident, the 21-day period shall begin from the date of appointment of counsel. If the defendant elects to proceed pro se, the court shall advise the defendant of the 21-day deadline. The court shall hold a hearing on any objection. Okay. Beginning July 1, 2023, the Division of Criminal Justice in the Department of Public Safety shall create an annual report, including all the information that is reported to the division, some kind of annual report there. All use of force by its peace officers that results in death or serious bodily injury, including date, time, location, perceived demographic, names of all peace officers, type of force used, severity and nature of injury, whether the peace officer suffered injury, severity of their injury, peace officer was on duty or not, whether the weapon was unholstered or not, whether the firearm was discharged or not, whether the use of force resulted in an investigation, whether it resulted in a citizen complaint, all instances in which a peace officer resigned while under investigation, all data relating to contacts conducted by its peace officers, including the perceived demographic, whether the contact was a traffic stop, the time, date, and location of the contact, the duration, reason, suspected crime, result, what the action was, property seizure, citation, warning, if a warning or citation was issued, if an arrest was made, the driver's information, actions taken by the peace officer regarding searches, whether the peace officer seized property, whether there was unholstered weapon, etc., 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 etc. Lots of reporting requirements now. Notwithstanding any provision of law, if any peace officer is convicted of or pleads guilty or no contest to a crime involving the unlawful use of or threatened use of physical force, a crime involving the failure to intervene in the use of unlawful force. So if you fail to intervene in the use of unlawful force, or if you're found civilly liable for the use of unlawful physical force, or found civilly liable for failure to intervene in the use of unlawful force, the board shall permanently revoke the peace officer's certification. The post board shall not reinstate the peace officer's certification or grant new certification unless the peace officer is exonerated by the court. The board shall record each decertified peace officer in the database. There will be a database created. Prohibited law enforcement action in response to protests. In response to a protest or demonstration, a law enforcement agency or any person acting on behalf of the law enforcement agency shall not discharge kinetic impact projectiles and all other non or less lethal projectiles in a manner that targets the head, pelvis, or back, shall not discharge kinetic impact projectiles indiscriminately into a crowd, or shall not use chemical agents or irritants, including pepper spray and tear gas, prior to issuing an order to disperse in a sufficient manner to ensure the order is heard and repeated if necessary, followed by sufficient time and space to allow compliance with the order. Civilian action for deprivation of rights. This looks like it's some kind of civil rights law now. Peace officer employed by the government under color of law, subjects or causes to be subjected, including for failure to intervene any other person to the deprivation of any individual rights. Any individual rights that create binding obligations. They are then liable to the injured party for legal and injunctive relief or any other appropriate relief. Statutory immunities and statutory limitations on liability, damages, or attorney's fees do not apply to claims brought pursuant to this section. The Colorado Governmental Immunity Act does not apply to claims brought pursuant to this section. Qualified immunity is not a defense to liability pursuant to this section. That's remarkable. In any action brought pursuant to this section, a court shall award reasonable attorney's fees and costs to a prevailing plaintiff. In any actions for injunctive relief, a court shall deem a plaintiff to have prevailed if the plaintiff's suit was a substantial factor or significant catalyst in obtaining the results sought by the litigation. When a judgment is entered in favor of a defendant, the court may award reasonable costs and attorney's fees to the defendant for defending any claims the court finds frivolous. So I guess what this last sentence means that if you bring a frivolous action against the police, the costs and attorney's fees can be awarded to the police as well. Notwithstanding any other provision of law, a peace officer's employer shall indemnify its officers for any liability incurred by the peace officer for any judgment or settlement entered against the officer for claims arising pursuant to this section, except that if the peace officer's employer determines that the officer did not act upon a good faith and reasonable belief that the action was lawful. So not clearly established, but rather good faith and reasonable belief, then the peace officer is personally liable and shall not be indemnified by the officer's employer for 5% of the judgment or settlement, or $25,000, whichever is less. Notwithstanding any provision of this section, if the peace officer's portion of the judgment is uncollectible from the officer's employer, or insurance shall satisfy the full amount of the judgment or settlement. A public entity does not have to indemnify the peace officer if the peace officer was convicted of a criminal violation for the conduct from which the claim arises. So that means that if they have the guts to go through with a prosecution and get a conviction, then they do not have to indemnify the officer further. A civil action pursuant to this section must commence within 2 years, so a 2 years statute of limitations. Use of force, special relationships. The use of force upon another person that would otherwise constitute an offense is justifiable and not criminal under any of the following circumstances. A superintendent or other authorized official of a jail, prison, or correctional institution may, in order to maintain order and discipline, use objectively reasonable and appropriate physical force when they believe it's necessary to maintain order and discipline. But he or she may use deadly physical force only when he or she objectively reasonably believes the inmate poses an immediate threat to the person using deadly force or another person. And they remove the section where it says it's necessary to prevent death or serious bodily injury. And I think they changed it to this section. Another section says use of force by peace officers. Peace officers in carrying out their duties shall apply nonviolent means when possible before resorting to the use of physical force. A peace officer may use physical force only if nonviolent means would be ineffective in effecting an arrest, preventing an escape, or preventing an imminent threat of serious bodily injury or death to the peace officer or another person. When physical force is used, a peace officer shall not use deadly physical force to apprehend a person who is suspected of only a minor or non-violent offense, shall use only a degree of force consistent with the minimization of injury to others, shall ensure that assistance and medical aid are rendered to any injured or affected persons as soon as practicable, and shall ensure that any identified relatives or next of kin of persons who have sustained serious bodily injury or death are notified as soon as practicable. A peace officer is prohibited from using a chokehold upon another person. For the purposes of this subsection, a chokehold means a method by which a person applies sufficient pressure to a person to make breathing difficult or impossible, and includes, but is not limited to, any pressure to the neck, throat, or windpipe that may prevent or hinder breathing or reduce intake of air. A chokehold also means applying pressure to the side of a person's windpipe to stop the flow of blood to the brain via the carotid arteries. A peace officer is justified in using deadly physical force to make an arrest only when all other means of apprehension are unreasonable given the circumstances, and the arrest is for a felony involving conduct including the use or threatened use of deadly physical force. The suspect poses an immediate threat to the peace officer or another person. The force employed does not create substantial risk of injury to others. A peace officer shall identify him or herself as a peace officer and give a clear verbal warning of his or her intent to use firearms or other deadly physical force with sufficient time for the warning to be observed. So I'm gonna shoot or something like that, I guess. Unless to do so would unduly place the officer at risk of injury or would create a risk of death or injury to other persons. Notwithstanding any other provisions in this section, a peace officer is justified in using deadly physical force if the peace officer has an objectively reasonable belief that a lesser degree of force is inadequate, and the peace officer has objectively reasonable grounds to believe and does believe that he or another person is in imminent danger of being killed or of receiving serious bodily injury. Then they add in a section here about a duty to report the use of force. A peace officer shall intervene to prevent or stop another peace officer from using physical force that exceeds the degree of force permitted. A peace officer who intervenes shall report the intervention to his or her immediate supervisor. The report will include information like time, date, place, etc. A law enforcement agency or member shall not discipline or retaliate against an intervening peace officer. Any peace officer who fails to intervene to prevent the use of unlawful force as prescribed in this section commits a misdemeanor, and nothing prevents a different or higher charge as well. When a judge or investigation finds that a peace officer failed to intervene, this finding must be presented to the district attorney so that he or she can determine whether charges should be filed pursuant to this section. Nothing prohibits the district attorney from charging before the conclusion of an investigation or court proceeding. In addition to any criminal liability and penalty, when a judge or investigation finds that a peace officer failed to intervene, the peace officer's employee shall subject the peace officer to discipline up to and including termination to the extent permitted by applicable constitutional and statutory personnel laws and case law, and the board shall permanently decertify the peace officer upon receipt of notice of the peace officer's discipline. The revocation may only be overturned if the officer is exonerated by a court. In a case in which the prosecution charges a peace officer with offenses related to and based upon the use of excessive force, but does not file charges against any other peace officer or officers who were at the scene, the district attorney shall prepare a written report explaining the basis for that decision not to charge the other officers, except that if disclosure of the report would interfere, etc. And then they have to delay disclosure for 45 days. Rights afforded to victims. In order to preserve and protect a victim's rights to justice and due process, each victim of a crime has the following rights: the right to be heard in any court proceeding involving a subpoena for records concerning the victim's medical history, mental health, education, or compensation, or any other records that are privileged, involving a petition for expungement, involving a hearing as described in another section of the law, and the right to obtain any incident recording. And then under a section called Public Integrity Patterns and Practices, it is unlawful for any governmental authority or any agent or person to engage in a pattern or practice of conduct by peace officers or by officials or employees that deprives persons of rights, privileges, or immunities secured or protected by the Constitution or laws of the United States. So systemic racism, maybe, is being attacked there. Whenever the Attorney General has reasonable cause to believe that a violation of this section has occurred, the Attorney General may, in a civil action, obtain any and all appropriate relief to eliminate the pattern or practice. Before filing suit, the Attorney General shall notify the government authority or agent and provide it with the factual basis that supports their belief that a violation occurred. Upon receipt of that basis, that agent has 60 days to change or eliminate the identified pattern or practice. If it is not changed, After 60 days, the Attorney General may file suit. The Police Certification Board may revoke the certification of a peace officer who fails to satisfactorily complete peace officer training. Prior to revoking the certification, they shall notify them and give them 30 days to complete the training. The Attorney General may enforce the provisions of this Part 3 through an action in district court for injunctive or other relief against any individual undertaking or attempting to undertake any duties as a peace officer in this state in violation, any agency permitting any individual to undertake duties in violation. The Attorney General may bring criminal charges for violations of this Part 3 if the violation is willful or wanton, or they may impose fines upon any individual for failure to comply. The Attorney General shall be entitled to recover reasonable attorney's fees. Under a section called Profiling, Officer Identification, Training, a peace officer shall have a legal basis for making a contact, whether consensual or non-consensual, for the purpose of enforcing the law or investigating possible violations of the law. After making a contact, a peace officer shall report to the peace officer's employing agency the perceived demographic information of the person contacted, provided that the identification of these characteristics is based on the observation and perception of the peace officer making the contact and other available data. Whether the contact was a traffic stop, the time, date, location, the duration, the reason, the crime, etc., etc., etc. We looked at this before. They had a section just like this above. Appropriations. And here's a bunch of appropriations. $617,000 is appropriated for use to the Department of Public Safety by the Colorado State Patrol. $50,000 for civilians. $7,500 for operating expenses. $463,000 for technology, $96,000 for legal services. This act takes effect immediately, except the parts about the body-worn camera begin July 1st, 2023. And they declare that the reason for this act, so this would be what, rational basis, is the immediate preservation of public peace, health, and safety. And from what I understand, this has actually passed. I believe that's what the headlines are saying here. So let me know what you think in the comments below. That is really remarkable. If you don't know what qualified immunity is, real quick, qualified immunity is a legal doctrine that protects police officers from personal liability. Imagine you're a police officer, you work for somebody, you work for a law enforcement agency, so you work for the police department. If you do something in hurt somebody in your job, can they sue the police department? Yes. Can they sue you? Not under qualified immunity, as long as you were doing your job correctly. This takes that away and requires what appears to be at least a 5% or $25,000 personal liability by the police officer, even when they're acting in the course of their duties, and changes the standard for any kind of immunity or protection to a standard of not acting upon a good faith and reasonable belief that the action was lawful. So there could still be pitfalls in there, but they seem to be changing the qualified immunity standard to good faith and reasonable belief. And if that's violated, then they are liable personally. The officer is liable for 5% of the judgment or settlement, or $25,000, whichever is less. So it's not taking away qualified immunity completely, but it is at least taking away other courts' interpretations of qualified immunity and creating their own. So that's really remarkable. It's a really remarkable response to the current climate where police feel like it's us against them instead of everyone on the same side, and we're all trying to figure out how to get along. Anyway, let me know what you think in the comments below. I'll let you go there. I'm Leonard French, your favorite copyright attorney. That's our show. This is a community-supported show. We would not be able to bring you our legal education news channel here on YouTube, Lawful Masses, without your financial support on patreon.com/ljfrench and sponsors.com/law. So please consider donating on a monthly basis. Thank you to our $50 plus supporters in the month of June: Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Josh Baker, Gregory, Rudolph Bescherer Jr., Kristian, Hellman, Jay Dixon, Ameknight, Oscar the Phrophet, and Hot Grills in your area. And the $5 plus supporters are scrolling on that LED panel behind me and on the crawl in front of me. And we'll see you in the description of the videos. Love you all. I'll see you later. Bye. Okay. Wow. Girl. What a good girl. Okay, I'm gonna go inside and see about lasagna. Okay? Okay? No? Not okay? Not okay? I'm gonna go inside and see about lasagna. Is that okay? I love you. Oh. Of course.